So it is my pleasure to welcome you on behalf of the FeBo team and together with Jens Wölke, leading expert in contemporary federalism and conflict resolution issues, to welcome you to our 8th FeBinar, the talks organized as a part of our ERC project here in Trento, FeBo. The FeBinars are part of a kind of think tank of the FeBo project, and our aim is to investigate the complexity of the dynamics affecting the internal and external border or border areas of Greek koina. Our focus is on a big question: how can border wars be avoided, and how can federalization processes contribute to this? And as a consequence, we need to work on hot topics in the current debate, such as the linearity of borders, the porosity of borders, the capacity of federal states to implement border management policies, border management cultures, bottom-up, the relevance of cross-border activities, and balances of power. The bibliography on these topics is enormous and still in a state of flux. And for this reason, we have invited and will be inviting experts on the mentioned topics. By me, I intend Claudio Biagetti, Rebecca Massinelli, Sebastian Scharf, and Roy van Wyk, and me. Since intra-federal borders and external borders must necessarily be approached from various research perspectives and with different questions, FeBo organized 2 distinct series of lectures, each with another focus, one on internal, the management of internal borders by federal states, and the other on external borders, crossing federal borders, ancient and modern. And both series have been initiated by the lecture delivered by Hans Beck on March the 7th, which focused on a case study which was both on internal and external borders. In the framework of our ERC project, this FeBinar is the 4th one of the FeBinar series, the management of internal borders by federal state. This series, which will run for 3 years like the other one, aims to analyze how Greek federal states dealt with the problem of intra-federal border and border areas. Did border management policies aim at peaceful coexistence? To what extent were balance of power and stability an objective? These and other questions we are asking presuppose other thorny issues. What borders are we talking about? The borders of police, of districts, between districts. What are the internal borders of federal states? What was the relationship of the federal states to the territory? How did they organize it? What was the relation between territory and membership, another thorny issue? And to what extent could the latter become more significant than territoriality? Das zwischenstaatliche Schiedsverfahren im archaischen Koinon zur friedlichen Streitbeilegung nach den epigraphischen Quellen is a well-known seminal book from 1998 that sits firmly on our desks. We all know that Kaya Harter-Uibopuu has his name written much more on these topics, and we all have so many questions for her, with many we already assaulted her this morning during our internal meeting, 3.5 hours, with PhD students and with our FeBo team, and I'll throw them in a few. Is there a kind of international flow that the Greeks could apply in the regulation of border disputes? Are there appreciable differences between the way conflicts between members of a koinon and between polis that are not members of a federal state are regulated? What is the role of the koinon in the former case? Are the object of dispute more linear borders or borderlands? And then there are all the legal issues. For example, who determines who is competent for the dispute? Is the agreement of the disputing parts on the matter necessary? How are any future conflicts settled? The legal question also concerns the comparison that can or cannot be made with respect to the contemporary world. And for this, I leave the floor to an expert on contemporary federalism and conflict resolution issues by federalization process, as well as an advisor of the European Union, Jens Wölk. Please.
Thank you very much. Good evening. Thank you for the invitation and the occasion to put the contemporary lens on the topic. It's a bit disappointing because I would dare to say that border management in the strict sense is not so much a topic which is important in contemporary federalism. We can even say in theory, in international law, the inviolability of borders is the principle and the absence of war. Unfortunately, as always, international law in theory, in law in the books, and law in practice is a bit different, as we can unfortunately see with the war of the Russian invasion in Ukraine in particular, and a lot of border issues around Russia. We can also see coming a bit closer to an area which is already for some time preparing for EU accession. I'm talking about Kosovo and Serbia. So there are a number, and this has been a federal conflict, of course. So this was the relation. But I'd like to focus, if I may, for 2 or 3 minutes on the question of the settlement of disputes, which in a more general way, and I try to relate this also to some extent to these border questions. Here I would start very far away, which is in South America with Mercosur, where we have an organization which is often compared to European integration, to the European Union, but of course is not that advanced in terms of integration. And in particular, with regard to the settlement of disputes, we have an organization which does not have a court, a permanent court. I think this is a very important difference, and this goes to the heart of dispute settlement, of course, because we have rather diplomatic settlement procedures, ad hoc arbitration, and as far as I've understood, this is also to some extent the talk of tonight. While in the EU, with a much stronger integration based on law, one of the core features of European integration is, of course, the European Court of Justice in Luxembourg. The idea of an independent court for monitoring what is happening in the implementation of EU law by the member states is already present in the Schuman Declaration, so even before the realization of the first 3 communities. No? So 1950 already, the idea of an independent court. And I think this is a very important feature, and I would even dare to say that this is a kind of federal. I won't talk about everything. No, because I have. Okay, it's a very federal element in European integration, and linking this to 2. Well, making a first in-between step. European integration is something which has been created by aggregation of states. Always, this is very important in contemporary federalism, that we are using models based on the aggregative path to federalism, while in reality, since the Second World War in particular, we have an empirical experience of rather the opposite. So this is the devolutionary path to federalism. So where a formerly unitary or slightly decentralized state then federalizes. And there are 2 clear examples here in Europe. One is Belgium, of course. And there, look, we have since 1985, so when the federalization process started to become serious, we have a court of arbitration, it was called, exactly by name. Only since 2007, it has been renamed because it has also gained other competencies, a constitutional court. So it was a kind of predecessor of a full-fledged constitutional court. The other example is the United Kingdom, which without a written constitution, at least not in one text, has introduced in 1999 devolution, and very few years after introduced a UK Supreme Court, which was unheard of before. Why? Because the settlement of territorial disputes between the devolved entities on one hand and the Westminster government on the other hand, that was an issue which should be resolved by independent judges. Why? Because the basic idea is always in more or less realized, and the case of the United Kingdom is not a good example, I have to admit. But in general, the idea is that there is a kind of equal dignity of the entities and the center, the federal government. And this requires that you can go in front of a court with complaints about one or the other sides for not respecting what? In contemporary times, of course, the Constitution, the federal Constitution, which is the yardstick, or in the case of the European Union, it would be the treaties of the European Union. So a kind of higher ranking law, which applies to both the federal level and the entities, or in the EU case, to the EU institutions and the member states. No? And this is what has been agreed upon. This is the federal compact. And so you need an arbiter, an umpire, for deciding on this. And then there are, of course, many other things which are important. There's Albert Dicey, the famous constitutional scholar from the United Kingdom, who said federalism means legalism, the predominance of the judiciary in the constitution. So this element of law, on one hand, of course, then the impact, the effects are very different in the single systems. There's something like legal culture, constitutional culture, path dependency. There are many things, but in a way, there's also self-restraint in some systems, which is in some systems more present than in other systems. But there is also a kind of transformative role of these judges, but maybe this goes a bit too far, so I will not dwell too much on this, but it's clear that if you have such a power as an independent court, you can either say, this is a political question, I do not decide, or you can jump on that question and try to transform the system with your judicial power. Just to finish, of course, these are issues which are to be seen on a wider topic together with the prevention on one hand and the resolution of conflicts. I have now focused on courts, and this would be the resolution side, but there's also a lot to say about the prevention of conflicts, which usually we put the label intergovernmental relations. And I think this is again related to what will be said today, intergovernmental relations and which are usually dominated by the executives, by the governments. And there are conferences, there are intergovernmental agreements, and there are also loyalty principles to follow. And this is all necessary in order to avoid going to a court because you can try to resolve conflicts already by negotiation this way. For finishing, many constitutions do have, and so I come back to the topic of the border management, many federal constitutions do have clauses on restructuring or reorganization of the federal territory. In Germany, it's the famous Article 29, which is used to be one of the longest articles, and which is always an indicator that it's complex. And in fact, it has never been implemented, actually never been used. But these articles usually contain the possibility to change the federal territory by a specific amendment to the constitution, and usually they foresee also a consultation of the population, if not a referendum, actually. Okay, thank you very much.
Thank you, Jens. We are looking forward to the FeBinar you will give for us. And we also look forward to hearing from our guest, Kaia Harter-Uibopuu, who needs no introduction, but I'll just say a few words for the younger ones, for students. Kaia Harter-Uibopuu studied at the University of Graz, where she was also an assistant professor of Roman law. She then worked with the Kommission für antike Rechtsgeschichte der Österreichischen Akademie der Wissenschaften and was lecturer in ancient law still in Wien. And in 2006, she was a Martin and Sarah Leibowitz member at the School of Historical Studies of the Institute for Advanced Study at Princeton, had a fellowship at Ohio University, and was shortlisted at Brown. I could mention numerous awards and fellowships that took her to 2015 when she became a professor in Hamburg. a member of the DAI, Deutsches Archäologisches Institut, Leiterin des Research Field B Inscribing Spaces since 2018, Sprecherin of the Excellence Cluster Understanding Written Artifacts, Director of the Graduate School of the Center for the Study of Manuscripts, Cultures, and now since May 2023, also project leader of the IG at the Berlin-Brandenburgische Akademie der Wissenschaften. Harter-Uibopuu is an internationally recognized expert on the topics she will be talking to us about today, and I am delighted to give her the floor to talk about these hot issues. Liebe Damen und Herren, dispute over land or dispute over borders, legal aspects of interstate conflicts in the Haiyan Koinon. Thank you.
Thank you very much for the kind introduction. I will try to start the...
It's all, okay. Should I do it? Yeah. Yeah.
This one?
Mm-hmm. Okay, it's not the first one, or is this the first one? No, I don't think so, but can I that works 10 minutes before beginning, and that
It might have been the wrong one.
okay, sorry, let me do this. Here, this one, okay, and then share again. This one, no.
Yeah, this one.
Okay. Okay. Full screen.
Yeah.
Okay. Now.
Yeah.
These are the right ones. Sorry.
Okay, so let's hope it works. If not, I think that somebody online might mention that to us. Okay, thank you very much, as I said, Elena, for the invitation. Thank you for this most interesting morning and learning more about your huge project. And I'm sure that we will be in contact about that for a longer time. For today, in the Achaean Koinon, peace between the member states was a necessity for the close cooperation and the consistent pursuit of common goals. This holds true for other federal states or less close unions such as Simmerhisp, not only in antiquity, but up to our days, as the example of the European Union constantly shows. It was theoretically impossible to attack your neighbor, least by the prohibition to send troops anywhere without the command of the League. So this should suffice, basically. But on the other hand, we can see that mediation, conciliation, and arbitration are among the peace-building and peacekeeping measures employed all over Hellenistic times, but also, and I would say rather frequently, in the Achaean Koinon. These three measures differ in the way in which the necessary third parties are involved. They differ in their competences and their influence on the course of the conflict. The decisive element is the consent between the parties, by which the parties agree on the arbitrator and on the exact object of the dispute. And they assure in advance in this consent that they will abide by the award in a so-called Kyria clause, a clause that we can find in private contracts as well. So this is part of a Greek contract, is to say, I'm entering into a contract and I'm promising that I will abide by what is in the contract. This is the difference between mediation and conciliation on the one hand and arbitration on the other hand. The former has a natural end if the parties are unwilling to reach a compromise. The latter, arbitration, provides a group of men with the power to actually decide, even if the parties don't get the compromise. Polybius, in a well-known passage, knew about this problem as he describes it in the events during the Fourth Syrian War, where mediation was not successful and arbitration not possible, because there was no one to interpose between them with the power of preventing and restraining any disposition that displayed itself to transgress the bounds of justice. Arbitration is a diplomatic measure that was very common in the Greek world of independent city-states, especially in Hellenistic times. Usually it was performed on an ad hoc basis. Two polis quarreling over the possession of land chose a neutral third party to decide their conflict. But what might be the role of federal states, especially for today, the role of the Achaean koinon? Were the member states free to choose arbitration in order to resolve their conflicts, or was it obligatory, thus prescribed by some kind of federal law or statute? This question was at the center of my PhD thesis, analyzing the epigraphic sources available until 1997. The thesis was published in 1998, and a few years later, I heard of the discovery of a new inscription in Messene, the nightmare of everybody dealing with epigraphic sources. The new stone holds a large dossier of documents pertaining to a dispute between Megalopolis and Messene, dating to the time after the conflict of the latter with the koinon in 183-2 BCE. The text proved to be crucial for our understanding of interstate law in the Hellenistic times and the role of the Achaeans, and has been treated, among others, by Nino Loraghi and Anna Magneto in a seminar article in the Chiron, Gerhard Thür in 2 articles, and Ilias Arnaoutoglu. Up to now, it has unfortunately not been published in its entirety. The last of the 4 columns still awaits a proper edition. Still, Petros Themelis, the excavator of Messene, was kind enough to present the full text in Vienna in 2011 and to allow Gerhard Thür to use the information of the last column as well, which Thür then made available to the scholarly public in 2013, albeit only as notes and without the text. The question for me was whether I would have to change my verdict from 1998, which was that obligatory arbitration did not exist in the koinon, now in the light of this new inscription. In order to re-evaluate the evidence, I will today concentrate on 3 topics, all pertaining to the legal background of the procedures rather than to the political circumstances. I will firstly talk about the disputing parties and the conflict situations, then about the objects of the dispute, and in the last step about the arbitrators and procedures. In a summary, I will attempt a response to the question raised at the beginning and provide a new solution, at least for some scenarios. In order to make it a bit easier to follow the sometimes a bit complicated descriptions of these quarrels and disputes, I'm using a color code. You will always have in blue the arbitrators and judges. You will have the parties to the disputes in red. In the case when we know who was basically the claimant or the one raising the conflict, let's put it like that, because in arbitration we don't have this clear role of claimant and defendant as we have it in private law. You will see that usually they would try to have it on a more neutral basis, but in case when we know who started the arbitration procedure, the polis will be on the left side and the defendant on the right side. And in green, I will present the object of the dispute. I will also present a map that you will see throughout the whole presentation. This is the map of the Achaean koinon in Der Neue Pauli. It does not show you the physical properties of the Peloponnese, which I think is usually very important because you need to know, do I have mountainous territory or flatlands or whatsoever? But it shows the most important cities of the koinon, which is not the case in every map that you would find of the Peloponnese. So that's why I chose this map. And this will be the pattern that we will see in the presentation. So let's come to the first part of the presentation and the question of the disputing parties and the conflict situations. Parties to the dispute in arbitration could, in the Achaean koinon, be both states, polis, members and non-members, as well, and I think that this is an important part, the koinon itself. So the league itself could be party to a case of arbitration. Still, I will start with the member states. This is the usual case of interstate arbitration in the koinon, starting with procedures as early as the 3rd century BCE. As I've mentioned before, the main sources are inscriptions either recording the award of the arbitrators or, and this is in the Achäan Canon, as far as I know, only in one inscription, honors for the arbitrators, honors for the judges, that would then be set up by the parties. Out of 12 disputes that formed the main basis of my PhD, it is clear that in 10, the parties were polleis, at least for part of the procedure. You will see that some of these cases are more complicated and have more than one instance of arbitration in them. Also, the dispute between Messenia and Megalopolis follows basically this example. So it's a dispute between the two polleis. And we will get back to this dispute a bit later. But let me start with one of the best preserved and best known examples. And I've just heard today that it was the one that you used successfully in the application for the ERC grant. This is the dispute between Epidaurus and Corinth over territory on their common border. There are two inscriptions pertaining to this quarrel. It's on the one hand, IG 41270. It's 59 in Peck's new edition of the inscriptions from the Asklepieion, the deed of acceptance for Epidaurus into the koinon, and then 71, the famous arbitral award. The conflict situation is rather typical, I would say. When polleis from the Argolid and Arcadia entered the koinon, any possible conflicts with their neighbors had to be eliminated in order to keep peace within the koinon further on. So we can see this in these entering agreements, that there is a list of things they want to clear before the new polis becomes a member of the koinon. In the deed, the first inscription, already the first part seems to pertain to judicial questions. Unfortunately, the text is very fragmented, so we are really down to guessing. It's probably pertaining to disputes between private persons, because what we get, what is mentioned are nomoi, dikai, which is clearly usually private cases, and klemata, as well as dicasteria. So it's the sphere of adjudication in some point, but not necessarily interstate arbitration. The second part, from line 17 to 21, then refers to the Corinthians, as well as to disputed territory and the Achaeans in total. So we get the Achaioi in this inscription. It is too fragmented to see an exact context, but it seems that the initiative came from Epidaurus, maybe through a certain position of strength, that Epidaurus knew that it was supposed to be a member of the league, and then argued, yes, I will enter into the league, but only if I get X and Y. Mitsos has shown by an analysis of proxenoi and theorodokoi published on stone in the sanctuary of Epidaurus that no Corinthians are to be found in the first half of the 3rd century in the Asklepieion of Epidaurus. And this is a clear indicator for a rather hostile situation, a hostile relation between Corinth and Epidaurus, which now had to be cleared. The text of the award is very straightforward, and it resembles other shorter awards of earlier times. The text states that the Megarians decided between the Epidaurians and Corinthians on the land, and that they had sent a dicasterion of 151 men to the disputed territory. So, katatade ekrinan, toi megareis, tois Epidauriais kai Corinthiais, peritas choras has amphelegon, on the land that was in dispute, kai peritus elantos, both on the land along the Sellas and the Spiraion, kataton einon ton achaion, I will return to that in a minute, and sending this dicasterion of 151 men. Please note that, as I said, the koinon itself, it's mentioned. Firstly, the award dates to the strategos of the koinon, and I think the dating formulas are important in these inscriptions. So the first date is epistrateguton achaion, that's what we want to know. And the second thing is that we hear that the procedure happened according to the ainos of the Achaeans. The term ainos is found rarely. Hesychius explains it as a gnome, a decision. So we are somewhere in the realm of a decision of the Achaeans. I think personally that here the ainos refers to the treaty of accepting the Epidaurians. So it's the decision of accepting the Epidaurians into the koinon to which this text refers. If it were not for the earlier treaty, we would not know that the initiative for arbitration had come from the Epidaurians here. Another feature typical for mediation being part of these measurements, because they don't want to present an obvious culprit in this scene. They want to present two equal entities. After the award, and we hear that simply the judges or the megares said that the territory is to belong to the Epidaurians. Krinanton, Epidaurion, Eimentan, Choran. So this is a very simple decision, A or B, it's A, it's the Epidaurians. After the award, we hear about another initiative. The Megarians had ruled that the land in question belongs to the Epidaurians, but the Corinthians contradict the thermonismos, the actual drawing of the border. Again, the Megarians send men, 31 this time, and all the 31, since we have the names, we know that all the 31 were part of the first panel. And these 31 come to the land in dispute, and they now define the border, and it goes on kata tade. So in the way that follows, etermonixan, they define the border. And what follows in the next lines, and I haven't given it here on the text, are 31 markers, both natural and artificial, along which the exact border is defined. So we have both a dispute on a certain territory that was decided, and then an appeal on let's get clearer on the border, and then they define the border, which usually is very uncommon because the decision of a court of arbitration should be binding and there should not be an appeal. Appeal is something that Greeks in a democratic dicasterion or in their jury system don't really foresee, but in this time they did. There was this definition of the border, which I guess must have had political reasons as well. The initial situation seems to be, as I said, rather common in the Koinon. We know that the covenant for accepting Orchomenos in Arcadia into the League shows that there had been quarrels over money owed to the city, which needed to be solved. We are not sure in the case of Orchomenos that there was arbitration as well, which could be on financial matters. An inscription mentioning a dispute between Argos and Cleonae is explained in the same way. Again, there are private disputes referred to as well as a dispute on territory. Still, I think that it is very dangerous to date the quarrels between poleis and make a connection with entering the koinon, because you start a vicious circle by saying that every time I have a border description in a certain time slot, I date it to the entering of the polis into the koinon, because I know the Epidaurus Corinth example. And then in the end, I can say, well, I have now 5 examples when entering into the koinon makes for a case of arbitration. So you have to be very careful here to look for situations or for information on whether we can date it closely or not. I think at least the quarrel between Messene and Figalia is an unsecure candidate on this kind of dating. But we have more secure candidates as well. And I think what clearly belongs into this category of disputes between an old member and a new member is arbitration between a member state and former parts of this member state, which were accepted as independent poleis into the League. This is the case in 2 cases of arbitration, on the one hand between Megalopolis and Helisson, and on the other hand between Megalopolis and Thuria. Plutarch reports on the dioikismos undertaken by Philopoemen, which will have given rise to several questions on land and borders that needed to be clarified. So there were certain territories taken away from Megalopolis, turned into independent poleis, independent members. And that's the situation when you have to say, okay, where's the border between the new polis and the old polis? And here we can be very clear about the date, I guess. The description of the dispute in several instances and the arbitral awards are published in Olympia, in both cases, Thuria and Helisson, and both of them are published on the same stone. And I think this is another important factor. It was only Hans Teuber in the IPAC, the inscriptions of procedural law from Arcadia, who realized that there are in fact 2 cases. Up to the IPAC, people thought that there was only 1 case, but Hans Teuber could show that there are 2 cases. Again, the fragmented inscription mentions a decision of the koinon. In this case, the decision is called grapton, and the Grapton was put down in the Synodos in Sicyon, in the Federal Assembly in Sicyon. The Grapton seems to have contained the fact that the Doris, a certain territory, was to be part of Megalopolis. We do not know whether this decision was in any way a judicial decision, something that a court would do, or whether it was a political decision. I would rather think from the description that it is a political decision in the wake of the Diarchismos. Given the date of the whole dispute, which is very close to the dispute of Megalopolis and Messene, there must have been major rearrangements in the central Peloponnesus. Partly these were resolved by arbitration, partly by political decisions, and partly by diplomatic means. So you have the territories here of Megalopolis and the northern border towards Helicon and the territories, and then you have the quarrel between Megalopolis and Turia in the south and the territories in between. Before I get to the example of Megalopolis and Messene, it's interesting to draw a modern parallel. After the dissolution of the Federal Republic of Yugoslavia, Croatia and Slovenia had a dispute not only over their common border, but also over the access to the high sea, which lasted for years. Basically, Croatia and Italy could have banned Slovenia from the open Mediterranean by executing their rights on the zone of influence. But Slovenia was already part of the EU when Croatia started the negotiations about entering. And Croatia, the case of the Bay of Piran, which is this question of access to the high sea, was to be dissolved by arbitration. Still, Croatia needed some persuasion to actually enter into this case of arbitration, and only agreed when Slovenia vetoed the negotiations. So they simply said, we are not going to let you into the EU unless you submit to this case of arbitration. What I find interesting in this case is that they chose arbitration and they did not choose a political decision. They could have said, we won't let you into the EU unless you grant us access, but they did not. They said, let's do it via arbitration, which shows that this is an important tool with a political meaning as well. As I've mentioned before, this is the inscription found in 2004, unearthed on the Agora of Messene near the Bouleuterion, in context with other texts on interstate arbitration that unfortunately have not been published. The stone of white marble limestone is a dossier, and it is presented in 4 columns. It's well readable, which sounds funny today, but it was in antiquity. And it was, according to the publication clause, part of an equestrian monument. So it's clearly a very impressive inscription that stood there on the Agora. The text consists of a psaphisma of the polis of Messene, a decree, which is supposed to serve, and this is said in the text, as a monument of memory to their victory. It then has a monetary fine by the Achaeans and the award of a group of Milesians. This is part of the last column. It is rather complicated to describe the different stages of the dispute, since they are mostly hidden in the psaphisma. So they are described by one of the parties to the dispute rather than quoted directly from the awards that we have. And what we have here is a very one-sided description of the whole affair, which one has to add. I'll still try, and I'm using basically the interpretation of Gerhard Thür, who sees the following steps in the chronological order of events, which is not the order in which they are presented in the inscription. So it starts out with Megalopolis, who is a member of the koinon, and who asked the neighboring polis Messene, at that time not a member, to submit to arbitration concerning a piece of land called Akraiatis on their common border. The two cities agreed to do so, and they choose a board of Mytilenaeans, men from Mytilene and Lesbos, but this never happened. So they just had this agreement, they choose to do it, and we never hear about a verdict or an award of the Mytilenaeans. Then Messene was forced back into the koinon, and there was a diarchismos again. Megalopolis now took the chance to ask the Federal Assembly for a political decision concerning 2 other pieces of land, Andania and Pylana, but the assembly did not want to act in this capacity. They did not want to have a political decision. They referred the affair to a further meeting and said that at this further meeting, or in the wake of this further meeting, arbitrators should be chosen. Megalopolis and Messene then still quarreled over the Akraiatis, and we hear that there was a diplomatic exchange, so there were embassies going to and from. In Elis, which is the next synodos of the Koinon, the parties agreed to submit to arbitration, and they defined 4 pieces of land: the Akraiatis, Pipaiatis, Andania, and Pylana. The gremium, the board in charge, are 17 hagemones of the Koinon, leaders of the Koinon, chosen specifically for this task. This is not a board of magistrates, a regular board of magistrates in the Koinon. It's a board chosen for this one situation. And then there follows a formal procedure about which I will talk in a minute. Curiously enough, again, in the whole presentation of the dispute, we never hear about the award of the 17 on Andania and Pylana. It's simply not mentioned. Yeah. There could be explanations as to that. The next step that we hear is that on the Akraiatis and the Pipaiatis, suddenly the parties change. So it was first a quarrel between Megalopolis and Messene, and now it's a quarrel between the Kaliatai, of whom we've never heard before, and Messene on these 2 territories, the Akraiatis and the Pipaiatis. But there is another case of arbitration. The city of Aigion is chosen as a polis ekletos, and I'll come back to that as well. The parties agree on that, and then we have this decision, which is now described. Megalopolis continues to fight for the Akraiatis. They just don't give up, and asks Messene to submit to yet another arbitration, although it was clear that there was an award on the Akraiatis between Messene and the Kaliatai. So Messene refused and said there has already been an award on that. And for refusing, Messene is fined by the Koinon to pay 3,000 drachmae. And then comes the last step, where the Achaeans, the Koinon, agrees to ask 6 Milesian judges to give a decision on the question whether this monetary fine was legitimate. And via arguing on the question of the monetary fine, they basically dissolve the whole dispute. The Milesian judges say the monetary fine was not legitimate. The Messenians were in their right to refuse arbitration. And via that, it's clear that they say the Akraiatis belongs to the Messenians, and there has already been the decision. And so now this is what the Messenians celebrate as victory, and this is what they present on the stone. And this is why this last decision is the last part actually on the stone. I know it sounds complicated. It is. I had to read the article several times until I understood what my teacher was trying to explain to us here. For the moment, please just consider that there are 4 cases of interstate arbitration, out of which 3 actually took place. Twice, the Megalopolitans and Messenians are the parties, once the Kaliatai and the Messenians, and in the last instance, the Messenians and the Koinon are the parties. What this complicated affair shows clearly is the possibility to play with the role of the parties. The Kaliatai turned up and kept the dispute going, and the Achaeans are party to one trial, which in the end turns out to be decisive. So by using different parties to the dispute, I can keep the dispute up. I can keep quarreling about it in a legal sense, not only in a political sense. And I think this is one of the most interesting features of this new inscription. But let's turn to some easier cases. Arbitration was not only possible between member states of the Koinon, but also between members and their neighbors. This is the case in the 2nd century BCE when Troezen has a dispute with Arsinoe. Troezen was a member of the League. The Arsinoe, the latter, was the only Ptolemaic possession on the Peloponnese. The Extant Covenant that we have in this case holds a compromise that the 2 parties agreed on, simply saying that they were to use the disputed territory together, the Isthmus of Methana, as common territory. Still, although they had this compromise, the 2 parties asked 3 Athenians to formulate the compromise as an arbitral award. probably to render more authority to it. So the idea was that a compromise is a treaty between two parties, but an arbitral award has more authority. So that's why we need that. So we ask somebody to have basically, it's not a fake proceeding, but it's something like that to say, pretend there was actually a case of arbitration and please formulate our compromise as an award. And in the light of the affair between Megalopolis and Messene, we understand why this might seem necessary. And I think that this dispute is later than the Megalopolis-Messene one. So yeah, that might be one of the reasons. There is another dispute in which Asinoe was involved between 236 and 228. It fought with Epidauros. But it is very unclear in this dispute where the object was actually situated. They do fight over land, that's clear from the inscription, but Epidauros and Asinoe don't share a common border. So there is a question on what this actually is about. While in the first case, Troezen and Asinoe, the arbitrators were from outside the Koinon, namely from Athens. In the second case, they are part of the Koinon, and we will see that in a minute. Let me, as a last point of part one, return to the disputes where the koinon is party to the dispute and not only the structure that's in the back of all of it. I have already mentioned the fine on the Messenians who refused to submit to arbitration. A very similar case is the case of the Achaean koinon versus the Spartans. The Lacedaemonians had, as we know from the inscription, constantly neglected older arbitral awards as the arbitrators in the dispute with the Megalopolitan state in their reasoning. The Achaeans again fined the member state and finally agreed on submitting this claim to a neutral decision. Of course, this submitting the claim to arbitration carried the risk that, as in the decision of the Milesians on Messene, the fine was overturned. But there will have been reasons for the koinon to act as a party and not as a sovereign. I do not think that we have an automatism here, but rather a decision on the spot, taking the political circumstances in the complicated history between Sparta and the koinon into account. Again, this is one episode of a long-lasting dispute. Inscriptions from Olympia 47, our main source on this dispute, presents the award of the judges in the case of Zamia. This is the actual case taking place. It's about the fine and not about land. And it just today, when thinking about the inscription again, I think we have to change the reconstructions in the beginning because there's something in the reconstruction that doesn't fit, but that's for another paper. So it presents the award of the judges in the case of the Zamia, but in explaining the decision of the judges, they refer to the history of the dispute between Megalopolis and Sparta, which is at the core of the affair. The first arbitral decisions were taken by Philip II in a larger effort to organize the Peloponnese after Chaironeia. Another political decision, not an arbitral award, was taken by Antigonos II. And in the preparation of the arbitration of 164, the one that we have here, even the Romans were constantly visited by envoys of the Spartans and the koinon in order to dissolve this conflict. Still, the parties to the dispute formally are the koinon and the Spartans. The decision on the legitimacy of the fine is in this case, in effect, a decision on the conflict over the whole disputed territories. So if we say the fine is legitimate, we have a decision on the whole conflict. A little bit different is the last instance where I could find the koinon as a party to a dispute. And this is the dispute between Aratos of Sicyon and thus of the League, I think, and Argos, as it is referred to by Plutarch in the Vita of Aratos. Now, the text here where he says they were prosecuted, the Achaeans, on the charge of having gone to war in time of peace, sounds fairly modern. And we cannot decide whether the koinon was forced to agree on arbitration, maybe by some kind of treaty, or whether it did so voluntarily. What we can say, and I think it's clear because you mentioned that in the introduction as well, what we can say is that there is no institution, there is no supranational institution where you could prosecute the Achaeans. So simply the Plutarch's way of describing it, Dikon Eschion is influenced by private law. It's how he wants to present the situation, but it's not what can have taken place. because prosecution would need a supra court in any way, and we don't have that. So it probably was arbitration, maybe on the basis of a treaty, but at least still it was arbitration that happened here. It will have been reasonable for the Achaeans to submit to this arbitration, and thus, all in all, we have 3 cases in which they were party to arbitration and agreed to be party to the arbitration. So this was on the parties to the dispute and the conflict situations. Let's now turn to the object of the dispute. Modern public international law excludes some topics from arbitration, such as vital interests of states. In antiquity, we don't hear of any restraints that have been in force. Still, most cases of arbitration that we get in antiquity are either about disputed land or about disputed borders. I've already mentioned the cases on financial questions as the fines, and there are a few other cases in the Hellenistic era as well that are on finances rather than on land or borders. In addition to the basic agreement on peaceful settlement through arbitration and on the judges, the precise definition of the subject matter of the dispute was also of great importance within the epitropé. That's the Greek term for this treaty of, or this agreement on arbitration, the compromis, which we find in the sources. The agreement not only obliged the parties, but also the arbitrators, who could not decide on other issues at their own discretion. So all of them were bound to this one piece of dispute. While the phrase perichoras, on land, in literary sources is often very unsatisfactory for legal historical considerations, the epigraphic evidence in many cases provides more precise information on what they were actually quarreling about. It should be noted that in a number of cases, either a precisely delimited area is named to which both parties lay claim in an antagonistic manner, or a new linear border had to be drawn that separated the opposing parties. The reasons why individual states were determined to possess relatively small border areas were as much economic as political and must be analyzed separately in each case. And I'm very much looking forward to everything you will work on these questions in your wonderful project. In the ordinary jury courts of the Greek polis, which were the role models for arbitration, there was always a decision between contradictory proposals. Large groups, be they specific dicasteria or ordinary assemblies of the state, would decide by vote for either of the parties and could not formulate their own verdict. This is what the term krinein in the dispute between Epidaurus and Corinth means, and in other examples. Krinein is always voting for A or for B. This is not formulating something. Still, already this example, the one of Epidaurus and Corinth, shows that sometimes emendations were necessary because krinein was done on the land, but still there were conflicts. A similar thermonismos, the drawing of the border, was conducted in a dispute between Epidaurus and Hermione. The compromise between the parties held that the territory was to be used together as a choinechora. But still, the borders needed to be clearly defined again, and this was done in the usual manner, combining natural and artificial markers in the landscape. So again, we have basically a territory which was defined until there was this award, and then they said, let's, just to make sure, let's have a linear border on that too. How does this defining of a linear border work? There are examples from central Greece which show that both parties presented the description of the border marker by marker to the arbitrators, who would then decide. And this is what is also was asked by the Messenians and the Megalopolitans when presenting their case to the 17 Hagemones. So basically, it's the same thing again. We have two antagonistic claims. One says, this is the border. The other one says, this is the border. And the arbitrators decide for either of the parties. But now comes a new way of dealing with arbitration. There are smaller groups of men, not only the big groups of dicasteria, but smaller groups of men, the so-called dikastai metapemptoi, foreign judges in modern scholarly terms, who were able to discuss their finding and to propose compromises. In the awards of these dikastai metapemptoi, we now often hear that sylosis, the mediation and reconciliation of the parties, was of utmost importance. And this could sometimes not be reached by a deciding between A and B. This antagonistic part does not hold a compromise. It does not really hold reconciliation. It's a decision. That's the basis of alternative dispute resolution today as well. I want a compromise. I want parties to agree and not only a clear-cut decision. I think that this was one of the reasons behind the development of these boards and behind the development that foreign judges came up in Hellenistic times and were used ever more often. Because they were smaller, they were more flexible, they were more engaged in what we would call today alternative dispute resolution, and they had peace between the parties as their aim. Therefore, the resolution of the arbitrators in the case of the Achaeans versus the Spartans holds extremely interesting general views on peacekeeping within the koinon, because we have a large explanation of the award of the arbitrators, which we do not have in the case when it's just a vote. Groups voting will never explain what they do. Groups formulating an award will explain why they formulate that. And this becomes ever more interesting for legal history. Again, it's the conflict between Megalopolis and Messene which shows how this game, as I would call it, of the object in dispute can be used for the profit of one or the other party. Although I have to remind you that we only have the Messenian story of the affair, so the description may well be rhetorical. So it's basically the court speech of the Messenians that we have. The object in the first dispute was the akraiatis. Then in the second dispute, they asked for akraiatis, pipaiatis, endania, and pylana. And in the third disputes, the kaliatai reduced the whole thing to akraiatis and pipaiatis. Andania and Pylana are never mentioned again in the whole inscription. And as I said before, the award of the 17 hagemones in this dispute is not quoted either. Therefore, Gerhard Thür believes that Messene actually lost Andania and Pylana and hid this fact in its tale of victory by concentrating on the disputes that they won. In between, there was yet another step to complicate measures in which the Megalopolitans had taken the fruits from the borderland, which should have belonged to both in a phase of compromise, thus forcing the Messenians to ask for another verdict. Each case was thus different, none about the same matter, although in the end, all of them were about the border region between the two cities. So it's always about the same region. But in order to have different cases, they had to make changes, either change the parties or change the object. So this works. The rule of excluding cases on which an award was already given was followed, because I can just change the case a little bit. In any case, all the parties had submitted to this rule in the arbitral agreement, the epitropee, because all of them swore that they would abide by the award of the arbitrators. So they had to become very creative to keep the question going. And I think this is what the case of Messene and Megalopolis shows. As stated in the introduction, mediation and arbitration are closely interconnected. Although they are very different from a legal point of view, given the competences of the third party, they go hand in hand. We will have to imagine that diplomatic efforts and mediation will have been the first stage to every case of arbitration. Even nowadays, the most difficult part of interstate arbitration is, on the one hand, to convince the parties to submit to a trial at all, and on the second hand, to define the precise object of the dispute. This is one of the things that you could see very clearly in the Piran case, when the question was not whether Slovenia had access to the high sea, but how Slovenia had access to the high sea. So by formulating the object of the dispute, I can already give it a certain twist. And I think that the ancient Greeks had this judicial capacity to really play around with the rules that they had. As for the sources, successful mediation seldomly found its way on a stone, unless ambassadors were praised for it. Awards of arbitrators were more common in inscriptions. In the cases in which they explain their ruling, we can see the importance of the syllosis, the reconciliation between the parties. Thus, the 5 judges chosen by Sparta and Megalopolis, as I said, state that they provided ample time to the parties to find a solution, even shortly before they formulated their award. It was thus possible to end the dispute right in the middle. Although you had already entered into the procedure, you could still say, stop, we have a compromise, let's not have a full award. But let me go one step back. Once the parties agreed on arbitration, there were 2 traditional possibilities to choose the third party, the arbitrator, the polis ekletos and the dikastai metapemptoi. The polis ekletos was the older system. As the name says, a polis was chosen who would itself determine the actual dikasterion. They could go for a civic assembly or present a court, sometimes as in the famous award of Argos, in a dispute between Melos and Kimolos. We are not even informed about what the board actually was. We are only told the Argives decided. It was the polis who was the authority behind the award and not specific groups. The Megarians decided in the dispute between Epidaurus and Corinth, and not the dikasterion decided. So the dikasterion is just part of the Megarians. In 3 out of the 12 cases I presented in my dissertation, we can be sure that this was the system. To my eyes, the case of Alifera versus Leprean falls in this category as well. Under the heading dikastai epiclarotentes, allotted dikastai, 2 columns of names follow. At least 21 to 41 men are mentioned here. And given the possible size of such a city, this would fit into the pattern of the Megarian award. Moreover, the new dossier of Messene Megalopolis shows that Aigion acts as a polis ekletos between the Kaliatai and the Messenians. It is not clear why the polis were chosen to act as arbitrators and why they agreed to take on the task. While in some cases a certain distance to the parties seems to have been preferred, as Aigion is distant to Messene and Megalopolis, the Megarians are the immediate neighbors of Epidaurus, of the Corinthians, and will have had knowledge of the whole troublesome affair. So you could choose a very distant arbitrator, but you could choose a very close arbitrator as well. There seems to be no rule to that. Unfortunately, we do not know who acted as the polis ekletos in the dispute between Megalopolis and its neighbors, Heleson and Turia. This would have been very interesting given the political circumstances, but the inscription is very fragmented. I've already talked a bit about the dikastai metapemptoi, the foreign judges, usually, as I said, usually found in scholarly literature as foreign judges or fremde Richter, and not the translation of sent judges, as we would have it in metapemptoi. This denomination comes from interstate complications rather than interstate law, and stresses the fact that the group of men were usually called when civic administration of justice was challenged by phenomena like stases or other internal crises. In these cases, neutral adjudicators from outside were expected to not only decide, but to bring about new agreements and peace, hence their focus on mediation and reconciliation. The smaller groups of usually 3 to 7 persons were ideal for these tasks, as they could act much more flexible than large assemblies. When choosing them for interstate affairs, and this is when they are foreign judges because they come from abroad, the reasoning was not to get the decision of an equal partner, as is the case of the polis ekletoi, but to bring a solution with which both contestants, the parties in the city, could live. They were chosen as individuals, not primarily as representatives of a polis. Still, usually they come from one polis. So usually these boards of 3 to 7 people are from one polis, but they're always named by their names. So it's not we asked the Milesians, but we asked X, Y, and Z from Miletus. The most extant description of this aim within the Achaean koinon comes from inscriptions from Olympia 47, the quarrel of Megalopolis and Sparta. The dikastai state, as I said, that they gave enough time to the contestants to find reconciliation, but in the end were forced by their oath and the laws of the Achaeans to decide the case. They did so in order for the Achaeans to live in peace and oinomia, and in order for former decisions to be held up, as well as for border markers to stay in place and stelae to be undisturbed. This is a clear description of what peace in the koinon should look like. Uphold the decisions, leave the markers alone, don't move them, and leave the stelae alone. Don't touch the stelae with covenants. This shows the most eminent problem, I think, of public international law. Any decision by a third party or any treaty is constantly challenged in its validity by changing political circumstances. Even today, with a supranational organization like the United Nations existing, having a set of rules agreed upon by its members, this becomes clear every day, that political circumstances just make people or states act in contravening these treaties. The dispute between Hermione and Epidaurus has already been mentioned. There are two inscriptions informing on the events, one from Hermione, the other from the Asklepieion in Epidaurus. The texts clarify that after a formal complaint by the Hermioneans, a proclasis, the Epidaurians agreed to submit the dispute. Two groups of each 6 judges are invited. They come from Miletus and Rhodes, so far away, but they are in Clator in Arcadia, acting as foreign judges, and the Epidaurians and Hermionians sent their envoys there and just pick them up there and bring them to the Argolid. They explained that they were provided with the competence to decide by both parties. They make that very clear in their award, and that they visited the contested territory before rendering the award. The award itself is unusual, as there are 2 awards. Both groups of judges issue one, but in the same wording. Both awards are published on the inscriptions, the Milesian award in the Ionic dialect of the Milesian judges and the Rhodian in Doric forms. Again, the introduction solves at least part of the riddle. It's called epikrinein and not krinein. And this is a parallel to the way of the 3 Athenians on the compromise between Troyzen and Arsinoe. I have argued in my thesis that this is the reason why the even number of judges, 6, did not cause problems. They actually did not need to vote in any case because they just had to formulate the compromise as an award. Still, the new dossier of Megalopolis and Mycenae clearly shows that 6 was considered a proper number for foreign judges, even for an arbitral decision. So I cannot be sure anymore whether my witty reconstruction of the Epidaurus-Hermione affair is still valid. Next to these 2 traditional ways of choosing arbitrators, the polis ekletos and the dikastai metapemptoi, there was a way that is only to be found in the Achaean koinon. And this is larger dicasteria made up by representatives from more than one city. Let me start with the first example. I told you that Epidaurus and Arsinoe were parties in a dispute over land, as IG 41272 reports. The letter forms of the inscription suggest the second half of the 3rd century as a date, and the letter forms suggest that the text is rather close to IG 41271, the Megara decision. So we might be in the first part of the second half of the 3rd century. Again, the inscription dates after the strategos of the Achaeans, but this time also the priest of the Epidaurians. 11 cities are being suggested, as line 7 states. And in line 8 and 9, we get the names Pelana, Aigion, and Telphusa. On the back side of the stone, we have a heading, Dikastai ekrinantode. The judges decided the following. And then we can see that there are columns of names. And in the middle column, we can see that it's Telphusioi. So what we can reconstruct is that the dicasterion was made up by groups, and they were named, they were listed in the groups of their home cities on the back when we get the whole list of the dicastai. The Telphusioi seem to be a middle column. If we reckon that each city sent the same amount of judges, something that maybe specialists on federal law might want to contradict, we would come up with at least 154 men in this quarrel, again, very similar to the body of the deciding in Megara. In both cases, the koinon did play a role. They are probably from about the same time, but from a legal point of view, there is a difference in the dicasterion of the 2 of them, because in one hand, I have one city, and in this other one, I have this composite board of judges. The composite dicasterion is also to be found in an inscription from Aigion, which clearly refers to a borderline and again dates to the second half of the 3rd century. Line 6 contains the word dikastai after a division sign, then follow the names of 59 men. Since the inscription is fragmented, it can be reckoned there must have been at least 100 judges in this case. Line 16 shows another division sign and then follows the ethnicon Dymaioi, so in the same way as in the Terfusa case. There must have been dikastai from different cities again. Unfortunately, it is impossible to guess more details of the dispute or the procedure. We don't even know whether Aigion was chosen as a neutral place for publication in the same way as Olympia, or whether it was involved in some way in the dispute. Still, I would think that this way of manning a court mirrors the federal structure of the Achäan koinon. Again, it's useful to have a look at the Messene Megalopolis dossier. Basically, all the ways of choosing judges are used at different stages of this dispute in different procedures. We have dikastai metapemptoi coming from Mytilene and Miletus in a small group each. We have Aigion as a polis ekletos, and we are even told that the people in Aigion use psephoi, voting stones, to find their decision. And then we have these 17 hagemones, on the other hand, who have a similarity to the specific Achäan procedure I just described, but they are not totally the same. Because in the first procedure, we have larger courts, and the 17 hagemones are maybe something like foreign judges, but coming from different cities within the koinon here. Christian Habich did a prosopographical analysis of the group, who are not magistrates in any way. It is published as an appendix to the article by Nino Loraghi and Anna Magneto. For now, it may suffice to say that these people came from Elis, Sicyon, and Achaia. There are no representatives of Arcadia who might have deemed biased because of Megalopolis. And the same holds, of course, true for the smaller Messenian cities, and obviously Sparta, who was always deemed biased and never was chosen as a judge. It is interesting, though, that neither representatives from the Argolith nor the Corinthia are in the board. And Joanna Kralli argues that the whole affair must have been seen as a topic for the old Achaia. The Messenian Psathisma describes the procedure that was held in the Karniasion, a sanctuary near Andania, and lasted for 2 or 3 days in quite some detail. There was a periegesis, a showing of the actual contested land. There were representatives presenting the arguments of both parties in speeches which were timed with a water clock. Interestingly enough, as I said, the award of the 17 is not part of the Messenian text. So, up to now, I have shown the variety of arbitral procedures applied within the Achäan koinon, foreign judges, polis ekletos, and the Achäan specific composite courts. Although the federal government was involved at various points, it does not appear to have specified a particular way in which arbitration had to be conducted. To my eyes, it seems to have provided a framework, the diplomatic forum for the parties to meet and discuss and then find their own way of peaceful resolution. But the question is, does this already constitute obligatory arbitration in the modern sense? The analysis of the epigraphic sources up to now has shown that arbitration was used in the typical way in the Achäan koinon, compared to other koinai, I would say rather frequently. Pressure seems to have been exerted on members to the extent that fines could potentially be imposed if one of the parties to the dispute refused to comply. This indirectly forced the disobedient town to give in and then be part of that. It is possible that this threat of monetary fines was made more often, or that the system was at least known to such an extent in the koinon that the willingness to settle disputes peacefully in this ways was encouraged, or let's say compulsory. Gerhard Thür sees this indirect force already as obligatory arbitration, but I would be more strict here. Obligatory arbitration, to my eyes, presupposes a system in which the use of arbitration in certain situations was not only indirectly required and enforceable through threats, but directly through existing law recognized by all. Now, another step that I was asking myself is whether we could explain the monetary fines in a way that there was a legal basis to them and not only an act of political decision by the Achaeans, and what could this legal basis be? We do know that the assembly of the Achaeans had the competence to act as a court when individuals acted to the detriment of the koinon, and it could then punish them. Polybius refers to verdicts against individual Spartans or Messenians in the course of the conflicts with the koinon, and Livy talks about a verdict against the Spartan Leonidas. We could assume that Messenia and Sparta as member states were seen as acting in the same way and were thus punished by the Achaean assembly. But this does not explain, and this is the main point of my difference with Gerhard Thür, why the Achaean koinon was willing to submit its own sovereign decision of putting a fine on somebody to arbitration. And maybe one thing is that we should mention what we never find is the assembly of the Achaean koinon acting as arbitrator. This is simply missing in all the different forms that we have here. So this does not work. Let us see how Thür solves the problem. The parallel for him is inner state law. When magistrates impose a fine on a private person, the private person can have the legitimacy of the fine controlled in two ways. Either he contradicts directly and turns to the police, or he simply does not pay and thus forces the magistrates to bring him to court and then has his case handled there. The parallel is a fine that you get for speeding when driving your car. So you can either contradict the fine directly or you choose to not pay and wait until the state does something. But basically, we have this system in inner state law in antiquity. This is the obvious pattern. But again, there is no superordinate authority when it comes to a decision of the koinon. In the case of Sparta and Megalopolis, the fine has been imposed by the Achaeans, and in the case of Messene and Megalopolis by the damiurgoi of the Achaeans. Still, in the latter case, the party to the disputes are the Achaeans, and not only the damiurgoi. So the damiurgoi are clearly acting in their representative function. So who should control what the Achaeans do if nobody is there that can control it? This means that the Achaeans had willingly submitted to arbitration. Luraghi and Magneto argue that it was the right of the member state to oppose to decisions of the koinon, of the federal government, and to force it to submit to arbitrations. But again, how could they force their federal government to submit to something when there is no structure that controls it? And for both solutions in international law, Thür's solution and Luraghi and Magneto's solutions, there are no parallels in our sources. So the problem is the same as it always is in public interstate law in antiquity, the lack of supra-institutions. We would have to conclude that the willingness of the koinon to have the penalty examined was based on political decisions. It might have suited them well at the moment of this crisis to submit to arbitration, to show that they were so secure that what they did was legal, that they could even go to arbitration. So this would be only a political basis. But I would like to shortly propose a different solution in the last minutes today that might provide a legal basis that bound the hands of both the koinon and its member states by looking for arbitration clauses not in the constitution, if that ever existed, of the koinon or other general rules, but in specific treaties between the koinon and separate parties. In our case, thus, treaties between the koinon and Sparta or between the koinon and Messene. I would think that these would be the treaties of accepting the city back into the koinon or at the first time into the koinon. For this, we do have parallels in antiquity, albeit not many, I have to state that. By analogy with private law contracts, compliance with interstate agreements could also be secured by a contractual penalty that became due in the event of a breach of the contents of the contract. Provision could then be made for a third independent body to decide on the legality of penalty payment if the penalized party lodged an objection. So if we have a contract and one of us obviously is in breach of the contract, we could in the contract agree if this situation comes up, we will choose an arbitrator who says whether there is a breach of contract or not. And yes, we do find that in Antiquity. An example from sphere of interstate relations are the two treaties between Antigonos Doson and the Cretan cities of Elaterna and Hierapytna. Elaterna and Hierapytna must pay a fine of 10,000 drachmas if they do not send the promised contingents of troops to the king immediately, or if they dissolve the contract in any other way. It is if they do not comply with the terms of the contract. An arbitration clause can be reconstructed with relative certainty because we have two inscriptions that kind of fit together, which provides for the appointment of a polis ekletos to be chosen jointly by the two parties, the Macedonian king and the Cretan city. Research generally assumes that this polis ekletos had to decide on the exact amount of the punishment, because the amount goes via which troops did I send and which troops did I not send. You can reckon the amount on numbers of soldiers. It's put together there. So research said this is what the polis ekletos does. It decides how much will they actually have to pay. However, as the text of numerous arbitration proceedings prove that adversarial motions must always be expected in these proceedings, I believe that the legality of the fine in its own may also have been at issue. Accordingly, the king would have claimed that the payment of the money for breach of contract was due, and the Cretan city would have defended itself by saying, no, there are no grounds for paying the money. We did not break the contract. This would correspond to the two penalties in the two trials between the Achaean Kainon and Sparta or Mycenae. The Achaeans say, there is a reason for giving you this penalty, and the other city says, no, there is not. The trial in which Mantinea decided between the Argives and the Achaeans on the 3,000 drachmas after the problems between Aratos and the heirs of Aristippus also fits this pattern. The legal basis for this is seen in a corresponding clause in a peace treaty. There must have been a treaty that says, do not go to war. And then there was the breach of this treaty. And this is why they could prosecute, or why they could bring the others to an arbitral, to a court of arbitration, and not the general rule of not going to war, which probably didn't exist in this way. Another example, a last example of such clauses comes from Asia Minor. The treaty that Ephesus and Sardis signed after mediation by the Roman proconsul Quintus Mutius Scaevola in the first years of the 1st century BCE was also secured against violations. If a city took any action against the agreed regulations, the contracting party had the right to have the matter heard in a polis ekletos, in an arbitration, in a case of arbitration. To this end, Ephesus and Sardis had agreed on a list of possible polis from which the mediating city, and we do not know who the mediating city was, drew a polis by lot who would then decide the case. Again, the subject of the subsequent proceedings must have been the question of whether one of the two parties had violated the treaty or not, and not only how high the penalty was. If we are to assume that in the Achaean koinons, the sanctions were imposed on Sparta and Mycenae because they had violated the terms of a specific treaty, we must ask which treaty this may have been. It is striking that both cities are known to have had difficult relationships with the League and to have left and re-entered the League at certain points. We know from other treaties between the koinon and potential members that conflicts were to be resolved as part of the membership process, and arbitration proceedings were also used for this purpose. Remember the treaty between Epidaurus and the League. So it would be possible that such procedures were also included in the treaties of accession between the Confederation and Mycenae and the Confederation and Sparta, or let's say of re-accession into the koinon. A contractual penalty that not only threatened the joining city, but also made the League liable, and the imposition of which could be reviewed by an independent external authority, could have been a compromise that provided the cities with a certain degree of security vis-a-vis the League leadership in an uncertain political situation. So it would be something the League gives to the cities that it is just bringing back into the League. Even if this is only kind of a show, it's still something that they can offer to Sparta and Mycenae. The two arbitration awards preserved in inscriptions would therefore be indirect evidence of this safeguarding of intergovernmental agreements. The obligation to submit to arbitration in these cases as the League was therefore not a general federal regulation that applied equally to all cities, but it had its basis in individual treaties. It is important to emphasize that it affected not only the cities, but also the federal government as a whole. In conclusion, it should be noted, and modern research agrees on this point, despite a disagreement on the details, that the need for peaceful dispute resolution through mediation, settlement, and arbitration was recognized at all times within the Achäen Koinon. In my view, any possible compulsion to resort to arbitration rather than other forms was based on different treaties between the Confederation and its members. The variety of procedural possibilities within these arbitration proceedings is exploited to the full by the parties to the dispute, by the mediators and the judges involved, and it testifies to the high level at which the instruments of interstate law, this toolbox that we can find in Hellenistic times, were available and used by the states. Thank you.